rest assured, I'm not going to read everything, my lord. I have deducted most of the things in reading, but everything should be there. And I'll tell your lordships the purpose behind it. What is the significance, my lord, of this? And what responsibility we on both sides carry to assist your lordships.
Lord, just for clarification, mine is a lead matter. We have filed our written submissions in.
That's okay.
Let him start. We'll make submissions after him.
Yes, of course. Lord, our response, why this is long, and I'm not going to read, my lord. Lord, the issue which my lords are, my lord, deciding is going to be a seminal importance for one reason, my lords. Lord, in the world, we have checked up, my lord, all jurisdictions, other countries also. Broadly, they can be classified in two categories. One set of countries who have adopted unicitral model law, and another set of countries, which are very few, who have modified their respective statutes to suit their domestic needs. Having examined both the statutes, which I will place, my lord, whatever is relevant, only perimateria provisions of section 34, all judgments, my lord, whichever we could lay our hands on, we have, my lord, tried and find out. In none of the jurisdictions, the question which your lordships have referred is answered. So whatever your lordship decides is going to be the first. And since, my lord, there are large number of countries who have perimateria provisions to our section 34, my lord, that would be cited. My lord, therefore, my lord, we have tried to encompass, my lord, the views of other jurisdictions also, so that your lordships can get, my lord, complete assistance from, my lord, all points of view, and your lordship's judgment, my lord, is accordingly, my lord, modified. Now, my lord, my submissions would be, my lord, in three broad categories. Number one, Lord, without examining the history of section 34, without examining the provisions of the Act of 1996, historically, it may not be possible for your lordships to examine in isolation section 34, its contours, and answer the question whether it encompasses the power to modify the award. So that would be, my lord, my first set of arguments.
You see, Mr. Solicitor, there are 2-3 things why we have expedited the matter is there are large number of issues, there are large number of awards. Arbitration awards in commercial matters is normally commercial agreements. This is the way most of the parties have been till now in India getting their disputes resolved. This matter is coming up in large number of cases.
Correct, my lords.
Almost every week, probably in Supreme Court itself, there will be about 3 or 4 matters in which this issue.
The High Court, much more, my lord. Your lordships are right.
And the High Court, maybe more. Arbitration is expensive. This cost factor is one of the bigger things. At the same time, it's quite clear the courts are not an appellate forum. Neither we exercise the complete power of appeal review. So we have to find a way out to deal with this problem. Where do courts interfere? Where do courts do not interfere? The new bill which is now introduced, we should not be commenting on it because we don't know what's going to happen. And in any case,
There is the appeal provision, etc. But
no, we are not concerned with the appeal.
It can be tweaked, it can be
No,
changed,
we are not on that.
etc.
But you're not on that.
Your
But
lordships
just-
are right.
But as far as this question is concerned, there are some amendments. I think one of the Union of India councils has, in their written arguments, referred to that. The new amendment.
Yeah, my colleague, my lord, Ms. Dave mentioned it.
Probably you have, in your case, you have referred. So, one is, we are not saying what do you mean by modification? And to what extent, if we accept partial modification without changing the substance of the award, without changing the core of the award, what will be the permissible parameters? First is, what do you mean by
threshold?
First is what is whether the threshold can be, because as far as severability is concerned, segregation is concerned, some of the written arguments accept that. Perhaps most of the written arguments accept that.
I have also accepted with one caveat that severability is for setting aside, not for modifying, in the sense that if there are 5 claims.
Now
and-
you may proceed. Now you may proceed. in your-
Yes, I'll bear, my lord, what is in your lordship's mind. My lord, kindly allow me to give a little history, my lord. I'll give the history. Thereafter, I'll show to your lordships, my lord, the provisions of other jurisdictions where the unicitral model law is followed by their respective legislatures. And there are 5 or 6 countries, which includes United Kingdom, France, Canada, United States, etc., where they have suitably tailored their respective legislations uh, without not going by strictly the unicitral model law. And third, my lord, my submission would be, my lord, that what can be the contours of your lordship's examination on answering the questions whether there is a power of modification or not. Because, my lord, it is my respectful feeling also, my lord, that some judicial oversight is necessary even to boost the arbitration. Lord, right now the position is that even arbitral tribunals are aware that 34 is almost a needle of the eye test, and therefore virtually the award is going to be final. And therefore, my lord, situations sometimes arise that the parties are not satisfied for more than one reasons, and that, my lord, kind of acts as a deterrent in going for arbitration. So the government is also interested in solving the problem. The question is how and by whom. Lord, now, Lord, our arbitration goes back, and I'll not, Lord, say anything which is not relevant for answering the question before your lordships. Our arbitration statutory journey, my lord, is from 1899. Indian Arbitration Act 1899 was the first. The purpose of showing, my lord, 3 sets of legislations in India for arbitration is to show that whenever the statute intended that there has to be a power of what they call varying the award, which we, Lord, in other words, say modifying the award. Lord, they have stipulated not only the power, but the contingencies under which it can be exercised.
Yes.
Lord, please directly come to, and I can again, my lord, assure your lordships, I will not read the whole thing, my lord, but whole thing should be before your lordships, when your lordships examines the matter and decides it, my lord. While delivering the judgment, your lordships must have everything on the table. That's the purpose, my lord. My lord, kindly come to para 3 directly. My lord, this is Arbitration Act of 1899. My lord, at the outset, I must say one thing, my lord. In the written submissions of my learned friend, Mr. Gaurav Banerjee, my lord, I find a very interesting and a very apt, correct line, my lord, at the end. I'm sorry, my lords. Mr. Banerjee's submission ends with a very intelligent, very correct, and very interesting line that over intellectualization of arbitration is India is the real problem. That's what my lord he has said. My lord, I'll take care that I do not fall into that. My lord, that was, my lord, I am told, my lord, by my lord Justice Narsimha. He has said that, my lord, but I'll add over intellectualization of anything in anywhere, any part of the world is generally the problem. But now kindly see, my lord, page 3. This is what, my lord, the provisions were. My lord, your lordships are at page 3. Right side bottom is the pagination.
Yes.
Power to remit award. Lord, this is 1899 Act. The court may from time to time remit the award to the reconsideration of the arbitrators or an umpire. Where an award is remitted under subsection 1, the arbitrators or umpire shall, unless the court otherwise directs, make a fresh award within 3 months. Lord, here there is no modification power, your lordship would mark. Lord, it comes in 14, which is widely construed by judgments, where an arbitrator or umpire has misconducted himself or an arbitration or award has been improperly procured, the court may set aside the award. But this again is power of setting aside, but improperly procured is very widely construed by various judgments. My lord, improperly procured would not mean, my lord, in the linguistic sense of the term, but it would mean that there was no valid arbitration, the contract was not valid, the arbitral tribunal has traveled beyond the scope of the reference, etc., etc. And, my lord, I have cited judgments, my lord, how it was widely construed. These are all, my lord, British judgments, because 1899, my lord, we had the British regime in place. Now, your lordships may kindly come to page 4. In that, my lord, 1899 Act had one schedule appended to the Act, which provided that these provisions of the then existing Civil Procedure Code would be applicable. That is, my lord, at the foot, my lord, page 4. These are provisions of the second schedule, which, my lord, incorporates by reference the provisions of the Code of Civil Procedure 1908, where the award or matter referred to arbitration may be remitted. The court may remit the award. My lord, remission is not right now, your lordships, my lord, scope of examination. Therefore, I'll skip. Kindly see 15. Grounds for setting aside award. An award remitted under paragraph 14 becomes void on failure of the arbitrator or umpire to reconsider it. But no award shall be set aside except on one or following grounds: corruption or misconduct of the arbitrator or umpire. My lord, very bold ground, my lord, specifically raised, specifically provided, B, C, etc. Lord, your lordships are not concerned with the grounds, because what I am respectfully trying to, my lord, show is that the power was setting aside of the award. No variation, no modification, no change, whether for good reasons or otherwise. Now comes, my lord, our Act 1940, which, my lord, which is the predecessor Act to the present Act. Your lordships may directly come to page 6 now. Page 6. Lord, this held the field from 1940 to 1996.
Perhaps earlier. Because there was an ordinance, there were a number of acts which came.
The 95 ordinance. My lord. But Act,
That makes no difference.
no, that doesn't make any difference, because 96 Act repeals this Act. So it continues, my lord. Lord, 14, I have, my lord, cited for completeness. Award to be signed and filed. Lord, your lordships need not read it. I'll just orally point out what the scheme was. Once an arbitral tribunal makes an award, it was directly not enforceable the way, my lord, we do it now. The arbitral tribunal was under a statutory obligation to place it before the competent court for its affirmation. And it became a decree of the court only when the arbitral award passes through that test, which is laid down in section 15 and 16. Nothing turns on that. That was the scheme. That it was not the moment award is passed, it didn't become the decree. It has to pass the scrutiny. But please see, my lord, section 15. Your lordships have section 15. Power of the court to modify the award. The court may, by order, modify or correct an award where it appears that a part of the award is upon a matter not referred to arbitration, and such part can be separated from the other part and does not affect the decision on the matter referred. Well, two things: specific power of modification conferred, and second, the severability or separability consistently, my lord, runs through 40 Act, Unicitral, and our Act, which I'll show. Meaning thereby, if they are so intermingled that they cannot be separated or severed, then it cannot be modified. That was how, my lord, this statute was judicially examined and interpreted. Where the award is imperfect in form or contains any obvious error which can be amended without affecting such decision. C, where the award contains a clerical mistake or an error arising from an accidental slip or omission. Now it is section 33. But it was a part of modification power of the court when the court is presented with an award for making it a decree of the court. So before making it a decree, there was a power of modification in 1948. Then 16, power to remit the award. The court may from time to time remit the award or any matter referred to arbitration to the arbitrators or umpire for reconsideration upon such terms as it thinks fit. Since the questions which are referred, my lord, does not pertain to power of remission, unless your lordship, my lord, would like me to assist, I may skip this. Because that your lordships are considering whether modification power exists or not. Power of remission, my lord, is retained to a limited extent even in the 1996.
If it has relevance, then you please address it. If you feel it may not be, some of the council may refer to the power to remit.
Let me, my lord, then point it out, my lords. Because remission would not include power of modification. Modification would mean without doing anything more, the 34 court itself modifies, changes, varies the awards. Not power of remand, that we find this lacuna, I send it back, you correct the remand. Right now we are concerned whether 34 court itself can modify, vary or change the award. But my lord, let me read 16. The court may from time to time remit the award or any matter referred to arbitration to the arbitrators or umpire for reconsideration upon such terms as it thinks fit. Where the award was left undetermined, any of the matters referred to arbitration, or where it determines any matter not referred to arbitration, and such matter cannot be separated without affecting the determination of the matters referred. So again, severability was, my lord, a part of the exercise of the power. D, where the award is so indefinite, so as to be incapable of execution. There may be such instances where it is so nobody can understand how to enforce it. While an objection to the legality of the award is apparent on the face of it. 2, where an award is remitted under subsection 1, the court shall fix the time within which the arbitrator or umpire shall submit his decision to the court, provided that any time so fixed may be extended, etc. An award remitted under subsection 1 shall become void on failure of the arbitrator or umpire to reconsider it and submit his decision within the time fixed. Then, my lord, judgment in terms of the award. Now it becomes enforceable decree in eyes of law, where the court sees no cause to remit the award or any of the matters referred to arbitration for reconsideration or to set aside the award. The court shall, after the time for making an application to set aside the award has expired, or such application having been made after refusing it, proceed to pronounce judgment according to the award, and upon the judgment so pronounced, a decree shall follow, and no appeal shall lie from such decree except on the ground that it is in excess of or not otherwise in accordance with the award. But somewhat similar to section 37 of the present act was absent there. It was almost final except this limited, my lord, ground of appeal. My lord, 18, I am not touching power of court to pass interim award. Please see section 30, grounds for setting aside award. Again, the grounds were only for setting aside, not for modification. Modification was 15 different grounds. Grounds for setting aside an award. Award shall not be set aside except on one or more of the following grounds, namely that the arbitrator or umpire has misconducted himself or the proceedings, that an award has been made after the issue of